Duncan says, if you want to know about business, health, and places to go, welcome to the show. Yeah, welcome to the show. If you know that you want to grow your business, your practice, and portfolio, welcome to the show. Yeah, welcome to the show.
Hello, and welcome to I'm Simply Saying, the healthcast where the spine meets strategy, alternative healthcare takes center stage, and we discuss how to build thriving medical clinics. I'm your host, Dr. Mary Frances Duncan, founder and CEO of Simply Southern Chiropractic Center in South Carolina. I'm a chiropractor by trade in an entrepreneur's body. I'm excited to guide you through this journey at the crossroads of chiropractic care, integrative medicine, and the art of successful clinic management. Lastly, if you take anything away from this episode today, please leave this podcast a 5-star review. Reviews allow us to hear from our listeners and what interests you. So, without further ado, let's get into the backbone of it all. Welcome to I'm Simply Saying.
Hello, and welcome to I'm Simply Saying. This is part 2 of car wrecks, necks, and checks, the personal injury basics for the chiropractor. Today, we are going to be also going through the same basics that we did through the first podcast with personal injury cases, defining some extra terms that we might have not discussed in podcast number 1, and additionally finishing up with the most important questions, how to get paid. And that is something that I know a lot of chiropractors have a big question about. So we're really going to get to break down that. Before we get started, I want to introduce Dr. Duncan, who is our host, and our special guest who we'll be having on this podcast, Will, who is Dr. Duncan's husband and a local personal injury lawyer in Greenville, South Carolina. If you take anything away from this podcast today, please leave us a 5-star review. These reviews help us get ideas and hear your feedback about these podcasts. And additionally, if you want any additional information, feel free to check out Dr. Duncan's website, drmaryfrancesduncan.com, where you can look into courses that she offers online, and additionally, one-on-one coaching with Dr. Duncan herself, who really will get to break down even more of this gray area that we're going to get to break down today. So without further ado, please welcome Dr. Duncan and additionally Will Maxey as we introduce, again, part 2 of personal injury cases in the chiropractic office.
Hey everybody, I'm Dr. Duncan, and today we have my husband, Will Maxey, with us. He is a local personal injury attorney in Greenville, South Carolina, and we are so thankful that he was with us for part 1 with our questions, and now we are going to finish up our talk about personal injury cases and chiropractors in part 2. So before we get started, Will, I'd love to ask you a little bit more about yourself. So tell me, what inspires you or who inspires you in the legal profession?
If I had to pick, I think I'm going to say this, but if I had to pick a single inspiration for wanting to be a lawyer, it's actually not even a real person. It's a fictional character, Atticus Finch from To Kill a Mockingbird. That really inspired me to be a lawyer because, this is a guy who takes on an incredibly unpopular client that everyone shuns in his town and doesn't want anything to do with. But Atticus Finch is willing to stand up for this guy, risk his entire professional and personal reputation because he believes that deeply in the Constitution, in the presumption of innocence, and in the legal profession. And, that's always stuck with me. It always will. I mean, I've read that book more than once. I've seen the movie a million times. We went to the Peace Center to see it. And, Atticus Finch has always been my inspiration for being a lawyer, even though, not even a real person. I always like to tell people, actually, that I have the same birthday as Atticus Finch, which is, sort of halfway true. It's Gregory Peck's birthday, who played Atticus Finch. So I always like to say that. So that's my guy right there.
All right. Well, I love the book To Kill a Mockingbird, and I knew that about you, and I thought that would be fun to share. So, before we get into more of the questions that I have for you, tell me, we talked about in part one that personal injury attorneys, they are friends to us as chiropractors. But tell us, what are civil defense attorneys and what are their opinions of chiropractors?
So civil defense attorneys, or sometimes, at least in this context, as they're referred to, insurance defense attorneys, are lawyers who are hired by the insurance company, but they represent the at-fault driver. It's kind of a weird relationship. If you try the case, they get up there and they say, I'm John Doe, I represent Jane Doe, who, they're trying to sue in this car accident case. While he does represent that person, really he works for the insurance company. I mean, that's who's paying his bill. That's who chose him to represent their insured. And so that's what they do, is they are representing the at-fault driver, but ultimately they're really doing the bidding of the car insurance company. And to answer your other question, it's a little bit of a nuanced answer, I would say, because some of it's generational. Like your middle-aged and older insurance defense lawyers are extremely hostile towards chiropractic. They think chiropractors are quacks. They don't know anything. None of it's real. It's all made up. They're just really anti-chiropractic. And again, I'm painting with a broad brush. There's some people that's an exception, but the younger you go, and this is an encouraging thing, I think, the younger you go, you meet more lawyers who either go to the chiropractor themselves, or they've seen, in their practice, some plaintiffs that they've deposed, like, wow, I mean, that really made a real difference for them. So I think you see more acceptance of that the younger you go. But generally speaking, civil defense attorneys are not friendly to chiropractic. And regardless of their personal opinion, in their professional work, they will try to discredit chiropractors however they can. Isn't it true? Every chiro depot, isn't it true you didn't go to med school? You don't have a medical degree. They might even, the older ones will refuse to call you doctor probably at the deposition. Oh yeah, they all do that. That is across the board. So that is something to keep in mind when you get involved in this kind of work.
Well, let's get started here, and we're going to talk about chiropractic treatment for personal injury patients. Then we'll discuss documentation, and then we will lastly talk about payment for personal injury cases. So, to begin, I think we need to define what MMI is, which stands for maximum medical improvement. Let's start there. What is the important? Can you define MMI and what is the importance of that?
Sure. Maximum medical improvement is essentially the point during the case where the patient has gotten as good as they're going to get, is the simplest way I could put it. They have improved as much as they possibly can. And, while you could continue to treat them, it's not going to improve their condition anymore at that point. It might keep them where they are, but it's not going to help them recover anymore. That's the point at which either the patient is fully recovered or the patient is just as recovered as they're going to be.
I think we're trained in school as chiropractors that, we want patients, we want to improve their daily activities. We want to improve the quality of their life. And sometimes, that can take a long time. A lot of chiropractors believe in maintenance chiropractic care to prevent unnecessary medications and unnecessary surgeries long term. But that, I think it's very hard sometimes for a chiropractor to understand that the personal injury patient, we only are treating them and billing the car insurance to get the patient back to how they were prior to the car wreck, which may not be their best self. And I think that this is very hard for chiropractors because it is a different mindset than what we are taught in school, and it's a different mindset of how we practice. So, can you talk about your experience with working with chiropractors and maybe when they treated past MMI and what that experience was like and what can happen if we overtreat?
Yes. Yeah, I'm happy to discuss that. One thing that I was taught in law school is that you should always text or email like it's going to be read in a deposition, right? You don't want to put anything down in writing that you wouldn't want read back to you at a deposition. The same goes for don't treat your patients like you won't have to explain it at a deposition. Because that's the problem a lot of chiropractors don't get is they have that mindset that you're talking about, Dr. Duncan. They think of it in terms of their philosophy or how they feel about this, but really you're going to have to explain why you continue to treat a patient and you expect the defendant or the defendant's insurance company to pay for it when they're reporting the same level of pain for 4 months after they probably should have been at MMI. And the fact of the matter is, if you don't have a good explanation for that, and if you try the case, the jury doesn't agree with your explanation of that, the patient's out a lot of money, and frankly, you're out a lot of money. So you need to make sure that you, as soon as your patient is not getting any better, and there's really nothing else you can do clinically, that you call it like that's MMI. Obviously, if they want to continue on as a maintenance patient, that's great, and I think that's good. I mean, I'm a maintenance patient. I mean, I get adjusted. There's value in that. People should do that, but you can't exactly ask a civil defendant in a lawsuit to pay for that forever.
Well, let's talk time frame and let's talk numbers. How much treatment is usually typical for a chiropractic personal injury case? And, what does that bill typically run, in an average car wreck case?
Sure. Okay. That's a great question. The dollar amount part is probably a little more local. And I practice in South Carolina, specifically upstate. So I'll just answer based on my experience. I think the duration part is probably a little more universal. I would say, if you're treating somebody, 3 months is a pretty solid time period. I mean, if you go into 4 months, fine. But just being honest, you can't have a case where you've treated somebody for a year, and you've got $20,000 in bills. I mean, the lawyer's never going to settle that case. The insurance company's never going to pay on that case. That case is going to go to trial, and you're putting when you do that, you're putting whether or not you get paid that amount or not in the hands of 12 strangers. I mean, that's what you're doing. So again, chiropractic maintenance treatment has value, but you've got to narrowly tailor like the accident related care to what you can show is something they needed because of the accident. And if you don't do that, you're really going to get yourself into a bind. As far as money goes, around here, I think if your chiropractic bill gets over $5,000, you're flying pretty close to the sun. I really think that's even probably a little steep, but obviously, that can happen. I would say on the low end, I mean, usually it's probably, at the very least, usually like $2,500, maybe $3,000. I've seen chiropractic bills less than that. I've seen chiropractic bills more than that. And again, I'm just a lawyer. I'm just reporting on what I've seen in my experience. I've handled hundreds of these claims. And y'all are the clinicians. Like, if you want to charge something else, as long as you can back it up, just understand you might be, like I was saying about emails in a deposition and treatment in a deposition. Same goes for billing. You're going to have to explain that bill in a deposition too. So these are all things that you need to keep in mind when you're making those kinds of decisions.
Do you think the price range, you said on the lower end, some of your chiropractors have bills in the $2,000 range, and then on the higher end, it's in the $5,000 range. Is that based off of the modalities that are offered in the clinic? Maybe some chiropractic offices only do adjustments. Maybe some do active and passive therapy. They have, a whole bunch of different therapies and treatments. Is that the difference in the pricing there, you think?
Short answer, yeah. I mean, that's it. I mean, a lot of chiropractors offices or chiropractic offices, sorry, don't do Graston. They don't do laser. They don't do, some of these other modalities that some offices offer. Like the ones that are on that really low end, they're really just doing manual adjustments.
Well, I think that's very helpful because I think a lot of our listeners may have questions about what makes $2,000 the lower bill in upstate South Carolina and what makes $5,000 the higher end range of a bill in upstate South Carolina. So for practice owners and for clinicians that are listening, in our clinic, we usually can get a patient to MMI within about 2 months. This is a typical case. These are not odd cases or cases that have, some other factors going on, but this is just a basic car wreck case. Typically, we see our patients 3 times a week for a month, and then we can drop them to twice a week for a month. And they have that's about 20 visits, and they have reached MMI. Sometimes we'll extend it a third month where we take the patient in and we treat them 1 time a week for a remaining 4 weeks, but that's rare. And again, I think even when I was starting in practice, it took me a long time to realize we're only treating and billing for this patient to get back to how they were prior to the car wreck. And you and I know this, everybody needs chiropractic care, and they probably were out of alignment well before the accident. And so you've got to be really careful with how long you treat a patient. And I think that's why it's so important to define what MMI is. All right. So can I include vitamins, supplements, and DME, so durable medical equipment like back braces or knee braces, into our treatment? If so, does the patient pay for these things, or can we bill this to the car insurance?
It's a good question. I don't actually think there's an answer that applies to all of those. I would say I think your durable medical equipment and back braces, things like that, that's a lot more defensible. I think that's fine as long as you're not, you know, just charging an obscene amount for that. I've seen some practices do that, and that's been problematic. But as long as you charge
Chiropractors or like physical
a
therapists?
physical therapist usually, but I mean I've seen a chiropractor do that before. But your durable medical equipment, back braces, things like that, I think you can pretty safely include that as part of the case. Vitamins and supplements, no. Uh, I don't see how you're going to show that that was necessary because of the accident. I mean, people ought to be taking vitamins anyway, and then same with any kind of supplements that you have. You can put that in the bill if you want, but you better not expect to get paid for it. Not from a car insurance company, I'll tell you that.
And I think this is great to get Will's opinion on this, because we know as chiropractors that there are things that can help with inflammation. There are supplements that we can offer to help with pain, but this is coming from an attorney, and he is talking about this and giving us an answer from his perspective and from a potential jury's perspective. And they're probably not going to consider vitamins and supplements necessary to the treatment of our patients. And this is why it's important. We do want the patient to go to the medical doctor if they can before they start treatment with us, because sometimes the medical doctor, they will prescribe prescription medication, and sometimes I've seen them prescribe vitamins as well. So I think we may not like this, but this is where people are not going to consider chiropractors and what we suggest and say in the same light as a medical doctor. Whether we like it or not, this is reality, and this is what this conversation is about: is the basic of personal injury cases and how to work them up in your office and how to get ultimately paid. So my next question is, our office in particular, we have a missed visit and a cancellation policy. So if our personal injury patient, if they miss an appointment and they, understand that this is a policy of ours, can we bill this to the car insurance company? Can we add it to their bill, or does the patient need to pay out of pocket for this, even if they are being treated on a lien?
Um, I would say I would probably not put that on the insurance company. I mean, they're not going to consider that. And frankly, I mean, I don't think a jury would think that was fair, that somebody should have to pay because somebody couldn't show up at their appointment on time. So, yeah, if you're going to do that, I think you need to charge the patient directly and just not make that part of the case. And I hate to skip ahead here, this kind of goes into your next question. If that becomes an issue, you need to nip that in the bud right away. Yeah, if you have a patient in a PI case that is not coming to their appointments, that's not showing up when they're supposed to, that's not compliant, that's a big problem. And here's why. An injured person in a personal injury case has a duty to mitigate their damages. In other words, they've got to do everything they can reasonably to try to lessen their pain and improve their injury. And what that means is you can't just get hurt in an accident and just go, "Oh my God, I'm hurt," and then just do absolutely nothing to try to address that, and then expect the other person to pay you for your pain and suffering. So you are the ones providing that mitigation of damages, right? The medical treatment. And so if they can't show that they're following through with that, and that includes following your instructions on when to be there and when their appointments are, that's going to be a problem for their case. And if it becomes like a real issue where they hadn't been in a week or 2 weeks, or you set the cutoff wherever you want, you need to call that lawyer's office and say, I'm not doing this anymore. Like this is the end of the case. Here's our bills. Here's our record. Good luck.
I think that's a great point to make. In our clinic, and we go over this with the patient before they start treatment, so they understand this and they sign saying they understand it. If they miss more than 2 appointments, then we're finished. Our treatment is complete in our office. Because if the patient cancels or misses, I think it's like Will said, it's very hard to explain to the insurance company why you continued treatment if they didn't stay with the frequency that they were supposed to. Because if the patient didn't come in for a week or two to some of their appointments, then was that treatment really necessary after they missed those appointments? And I think that's very hard to prove and very hard to explain. Going back to our missed visit policy in our office, if you have a missed visit policy in your office, I do suggest that you uphold this. And we go over this policy with our personal injury patients, even if they have signed a doctor's lien and they're not paying for treatment up front. We do let them know there is a charge if you cancel your appointment less than 24 hours before it's scheduled, or if you miss your appointment, you will be charged. And we require all patients, not only personal injury patients, to leave a card on file. And so we will go ahead and charge their personal card for that, and we do not charge the car insurance for that, because like Will said, it's not the car insurance's fault that the patient couldn't make their appointment. All right, so now what if our patient, as the clinician, as the chiropractor, what if our patient has been in a wreck and they need advanced imaging? We think they need an MRI. We think there's a herniated disc and we want to check it out. They need a CT scan, ultrasound, whatever. So who pays for that? How do we go about that? What do we do?
Well, and I think part of that has to do with what your scope of practice is in the state that you're in. Like if you're able to make those referrals directly, if your patient needs that kind of imaging, make that referral as soon as you can. As far as paying it goes, obviously, ideally, your patient would have health insurance or some way to pay for that. But if they don't, this is where, this is one of those examples where having an attorney can help. Because like I said, you don't love attorney directed treatment, but if somebody doesn't have health insurance and they have no way to pay for something like that, most lawyers will have some vendors that they could use a letter of protection with, which is basically a letter that the attorney writes to the provider that says, hey, I represent so-and-so. And at the end of the case, obviously any interest that you have would be protected out of the settlement. In other words, at the end of the case, assuming we get a settlement or verdict, we'll do our best to pay you back. I mean, you can't exactly promise I will pay you X amount. You can't do stuff like that, but you can send them an assurance that their interest will be protected out of the settlement.
Well, in our state of South Carolina, chiropractors, we can write a requisition for an MRI or advanced imaging. Would it be in the patient's best interest for the chiropractor to write that requisition directly, or would it be in the patient's best interest for us to refer them back to their medical doctor to then write a requisition for that advanced imaging?
I would say, generally speaking, is the best course of action to let the medical doctor sort of quarterback things, so to speak.
They're sort of a project manager. That's how I see them.
Yeah, no, that's right. And whether that's a primary care doctor or obviously if you've got a case that, a chiropractor looks at and is like, whoa, like this person's got some stuff going on, it's totally appropriate. And honestly, I think it's great for the case, if it's clinically necessary, of course, for y'all to make a referral to an ortho. And then the ortho orders that imaging, and then you just eliminate that issue entirely. But look, if in your clinical opinion they need some imaging, by all means go ahead. But just keep in mind, like I said, any decision you make, as long as you can explain it in front of that court reporter, in front of that jury, and just keep that in mind.
All right. So let's move on to documentation. So, what should my records look like? What should they include? What does a good record look like? I know you've seen a lot of records from a lot of chiropractors. What's good and what's bad?
All right, I'll tell you what's bad is those forms where the guy's like, he's got his head turned to the side or whatever, and they like circle different parts of the body, and then they take their little chicken scratch and just circle this and X that and put a random numbers here. That's terrible. That doesn't mean anything. I mean, I'm sure there might be some older chiropractors that heard me
Yeah,
say
those are
that.
called travel
Yeah,
cards.
yeah, and they don't love me saying that, but I'm sorry. Like that doesn't mean anything. Like you need to have a narrative that explains what it is you did in writing. You need to obviously have and I might call it the wrong number. I apologize, but the ICD-10 codes and all that kind of stuff that says what it is you're billing for. You need to be very clear, and this is a huge opportunity, I think, for chiropractic to kind of mirror what medical doctors are doing, because the more that you do that in your record keeping, the more legitimacy that your treatment has in the eyes of that insurance adjuster, or in the eyes of the jury if they see that. If the jury sees some, nonsense drawing of a human body with his head turned to the right and his mouth open and a bunch of chicken scratch, like that doesn't mean anything. It just doesn't. It might mean something to you, but it doesn't mean anything to the insurance adjuster, and it doesn't mean anything to those 12 jurors. So I think you need to have a clear narrative that's written out that explains what it is you did, what your client reported, and your subjective and objective findings with each visit. And that's what good records look like. Because that way you can use those records. And even when you're trying the case, use those records to say, he was reporting, 7 out of 10 pain. And then the next visit, it was 6 out of 10. 6 out of 10 again, then 5. And you can show that your treatment was getting it done. It was helping this person recover. And you also show that person, their pain is persisting. They are continuing to be in pain from this other person's actions. And that's the kind of thing that really helps a personal injury case and really helps your client, and also ends up helping you.
Well, tell me then, how once we have our records, we have good records. They're very complete and they're very detailed. How long do we have to turn these in? Because sometimes I get it, as a clinic owner and a practicing chiropractor myself. We want to do a good job with these records. We want to have a good um, we want to represent ourselves well with the legal community, and that sometimes takes us time to go back and dot our i's and cross our t's. So what is an acceptable time frame after the patient has finished their last appointment, to turning in those records to the attorney?
Oh man, medical records are one of the worst parts of being a personal injury lawyer by far. Um, and frankly, it's usually not chiropractors' fault. Y'all are usually some of the fastest ones in turning them around, but it can take, and it leads to a lot of frustration with clients, aka your patients. But with hospitals and orthos and surgeons and stuff, I mean, they can take sometimes up to 2 months to get records back, and that's just way too long. So the faster you can do it, the better. I would say with a chiropractor's office, if y'all could get them turned around in 20 to 30 days, I mean, I think that's pretty reasonable. Once you start getting beyond that, it becomes really onerous on the lawyer, also on the client, and also on you, because you're going to need to furnish those bills and records so that they can be part of the demand package that the attorney sends to the insurance company.
Well, I didn't know that. So that's good to know about. I didn't realize other providers took so long to give you guys records. In our clinic, I tell our doctors my personal rule is 2 weeks after the patient's last appointment, we need to have the records to the lawyer. And so we have great relationships with the lawyers that we do work with. We work with one in particular, we do a lot of work with him, and we really try our best. He treats us well, and we try to treat him well and get him those records as soon as we can at max 2 weeks after the patient's last appointment. So, Will, can we charge as a chiropractor a narrative fee? So, it takes us a long time to, we can print off the records from our electronic medical record system, the SOAP note, what we did each day with treatment with the patient, but it does take a while to sometimes write a narrative. And can we charge for that?
You can, I suppose, charge for that. I mean, I have had some carriers push back on that, and frankly, I kind of get the argument because other providers don't charge for generating medical records. That's just part of what they do.
This isn't a search
Um,
and retrieval fee. This is a
right.
narrative fee.
Yeah. So I mean, yeah, you can certainly charge copying fees, search and retrieval fees, but as far as like actually, charging them for generating your own records, I mean, again, I'm not a chiropractor clinician. I don't know what your standard of care is there. Personally, I would not do that. I mean, if you do, that's fine, but just don't get your feelings hurt if it doesn't get paid.
Well, tell us then, should a chiropractor charge an attorney a copying and administrative fee?
Um, you can. Certainly all the other providers do. I mean, they charge copying fees, retrieval fees. Some of those fees have frankly gotten a little ridiculous. I would keep them to a minimum, both because keep in mind, like I know it's easy in these cases to think like, well, I'm dealing with this attorney and this insurance company, but this is really your patient's money. That settlement money belongs to them. So when you're charging, it may feel like, oh, well, I'll charge this attorney this or whatever. It's going to end up being your patient that pays it because the attorney is going to get reimbursed his or her costs out of the settlement. So I would try to keep those fees as manageable and reasonable as possible.
In our clinic, we do charge a narrative fee. It does take us a lot of time to actually write the narrative about the accident and what the patient did after the accident, and talk about their activities of daily living and how those have been affected. And so we do charge a narrative fee in our clinic, but we never charge an attorney a copying fee or an administrative fee. So I guess maybe you could do one or the other. I don't want to charge if it's an attorney that we like and we want to do business with. I don't want to be charging them a fee for printing and copying. So um, that's very interesting, your take on that, Will.
Yeah, I mean, and again, like I don't know what the what the norm is. I'm just saying from what I've seen, and frankly, if that's something that chiropractors do nationwide, then keep doing it. As long as you're not deviating from the standards of care, deviating from the norm, that's for the best.
So we've gotten our records complete and we're ready to pass those along to the attorney. This is a question that I have myself. What is the best way to submit patient records? Do you like printed copies? Do you want us to send these electronically in a fax? I know with us, with HIPAA, we have to be very careful about sending patient records via email unless it's secure. But what is your preferred way of receiving these records?
I like maybe this is just our millennial lawyers, right? I like anything electronic if possible. Fax is fine because frankly, I'll drop a little spoiler alert for you here on the podcast, but most lawyers' faxes go to their email now anyway, so that's fine. I don't love uh, the mail, or I actually kind of like the drop off method if you are local. I mean, that's actually probably a genius marketing move from the chiropractor standpoint. And it's just nice to have a visitor or whatever. But I don't love mailed paper records. That's probably my least favorite of those options. Favorite being email. Obviously, whatever HIPAA requires of you as a medical provider, I mean, if you don't feel safe doing that, then by all means fax it.
All right. Okay, so after the patient is treated, what's next?
Well, once the patient's finished treating and they've met MMI, at that point, that's kind of where the attorney takes over as far as getting the case settled. The attorney takes all of the records and bills that are collected and puts them together in what's called a demand package, and then writes a demand letter addressed to the insurance adjuster handling the case for the liability insurance carrier, and asks for an amount of money to settle the case. That amount of money differs based on a number of different factors. The amount of medical bills drives the value of the case. The thinking is, well, the more medical treatment you have, that means you have more bills, and so the more medical treatment you have, the more injured you must be. That's sort of the thinking that goes into that style of analysis, and that's not always the case. Sometimes you have some injuries, and this doesn't really apply to chiropractic, but just for instance, you break your ribs, right? There's really nothing medically you can do for that. But it's an incredibly painful injury. And so your bills are kind of low because there wasn't really much treatment you got for that. But the value of that is higher because that was an incredibly painful thing you went through. That's one factor that goes into case value. If there's any punitive damages aspect to the case, and punitive damages means damages designed to punish or make an example out of somebody for their reckless behavior. The most common application in a car wreck case is a drunk driver, or somebody who's intoxicated by drugs, or that you can prove, and this is pretty hard, but you can prove was texting and driving or doing something really reckless like that. Those are damages above and beyond just medical bills and pain and suffering and things of that nature. So those are all things that go into how much an attorney demands. And then another part of it is how much insurance coverage does the at-fault driver have? Are they riding around with state minimums? In South Carolina, the state minimum is $25,000 of liability bodily injury coverage per person, $50,000 per accident. So if that's all they got, oftentimes the lawyer is going to go ahead and demand the limits and see what the adjuster says. Um, and then, that's where the attorney takes over, is that part is he sends that demand or she sends that demand, gets that offer back. Either the insurance company is going to do one of three things. They're either going to say, nope, I'm not paying you anything, not our fault. Or they're going to say, yep, we will pay you that. That's great when that happens. Or the most common answer is, well, we won't pay you that, but we'll pay you X. And then at that point, the attorney takes that offer to his or her client, discusses what they believe the case value is or should be, and then gets authority from the client to negotiate with the insurance company. And that back and forth sometimes happens over the phone, sometimes it happens over email. Some of your older lawyers might still send letters back and forth for that, which that I don't know why you would do that, but that back and forth can take a few weeks. So one thing that you need to understand as a provider is that when you get done with treating your client, that's really the beginning of the personal injury case as far as the lawyer is concerned. Up to that point, they've been waiting around for the client to get better, the client to complete their treatment. And that's where the work really begins, is putting that demand together, getting that demand out the door, getting that initial offer in, and negotiating. And that is, again, that's where the work is. So it's easy as a provider sometimes. I'm sure y'all are sitting here thinking like, well, where's my money? Like, I finished treating him. I gave you the bills. What else do you want from me? And I understand that, but these things take time. Adjusters have hundreds of these claims. Frankly, attorneys have a lot of these cases. And so it's going to take some time.
So on average, what would you say, what's the time frame after the patient is finished treating in the chiropractic office? How long does this take? And also, I think chiropractors, we need to remember that patients are not always only treating at the chiropractic office. So they may still have treatment that's ongoing in another facility or with another provider. But after all treatment is finished, what would you say the average amount of time would be for a case to settle?
So a lot of that's going to be driven by how long it takes to gather those medical records and bills. That can be really time consuming. I would say it's pretty reasonable to allow for, from the end of treatment, let's say 45 to 60 days for that, and then probably another 45 days or so to get the demand out, get that initial offer, and if you're going to get the case settled, pre-suit, in other words, before you file a lawsuit, um, another 45. So we're talking like after you finish treatment, it'll probably be at least 3 months before that case settles, if it settles. You may have to the attorney may have to file suit.
Well, in real life practice, the fastest we've ever gotten a payout from a personal injury case was 6 months. And then the longest one has taken us 6 years. So, average for us in the chiropractic office here in Greenville, South Carolina, usually is about 1.5 to 2 years until we get paid out. And so that's why I say, I would not totally rely on personal injury cases as your only form of patients. I think it's great to have a variety of cash paying patients, health insurance patients, and then personal injury patients. It's almost like a little bonus. You help the patient, you get them better, they reach maximum medical improvement, you finish up the case. They probably, in reality, are not going to stay on as a maintenance patient. And you do this case, you work it up, and then you send it off to the attorney. And then I tell myself and my doctors, just forget about the case. Put the case on the top shelf of your closet, and then in a couple of years, once it settles, then you get paid, and it's a nice little check for you in your office. But don't rely on personal injury payments to run your clinic and keep it going, because they're very unpredictable as to when the case will finish. There's a lot of factors that I have learned go into this. So, another thing that I want to talk to chiropractors about is when the personal injury patient finishes care. Sometimes, typically we will recommend maintenance care to our regular patients, and maybe your personal injury patient even ask you about ongoing care. And I think it is very, very important to make sure that you clearly define when a personal injury case is over. And I think this is important to educate your patients on what maximum medical improvement is and when they have reached it. And so the patient may say, "Oh, well, I still hurt," or I can't run the way I used to. And this is why it's very important to do a very good orthopedic exam and a neurological exam when you start, because you need to know how the patient is right after the accident, because the patient may not have felt the way that they want to feel before they had the accident. And you got to remember that this personal injury case, we are only fixing and or trying to fix, and we're treating the injuries that were occurred from the accident. So, Will, do you have any advice for chiropractors on transitioning a personal injury patient to maintenance care if they are interested?
Sure. I think the first part of what you said is especially crucial because the way that we usually find out when somebody's reached MMI is from the patient, is not from the doctor. So make sure you explain to them, as far as your injury case goes, this is it. Um, we can keep you on maintenance wise to try to keep you where you're at and make sure you don't get any worse. But as far as injury related treatment goes, we're done. So I think it's important to make that crystal clear and make sure they understand, because then they'll ask us, and then we start getting the wheels turning on what we need to do to get the case finished. So I think that's crucial. I think it's important to explain to the client, or sorry, to the patient clearly that if you do maintenance care, like you're paying for this. Like this has car insurance isn't paying for this. You can't come back later and get more car insurance money. Like you're paying for this, and this needs to be something that you want to do. Um, Frankly, I don't think a lot of your PI folks are going to stay on.
No.
I wouldn't expect that, but some of them will. I mean, there'll be a small percentage that will.
This is why personal injury, in my opinion, is not a sustainable practice model. So thank you. I think that clears some things up about MMI and maintenance chiropractic care. So, what are some possible things that can happen while a case is being worked up, while it's being litigated? Is the chiropractor completely finished with this case after they treat the patient, or can they be deposed, or can they be asked to go to trial? Tell us about that.
Sure. A chiropractor very well might be deposed. And one thing to keep in mind: this does not mean you're in trouble. This does not mean someone is suing you. Like just take a deep breath when you get that subpoena, read what it says, and see who the parties are. Right? There'll be John Doe versus Jane Doe. Well, you're not either of those people, so obviously you're not being. I say obviously to me as a lawyer, like obviously you're not being sued. But if you're not familiar with the court system, getting a subpoena for a deposition is scary, or a notice of deposition. But you're a witness in the case. In fact, you're an expert witness. Based on your education as a chiropractor, you're being called on to give opinions, and the only people who can give opinions in a case, generally speaking, are experts. So it's actually kind of a compliment. You're an expert witness, and so you'll be giving testimony about your treatment of your patient. And they're going to ask for certain. They may ask for certain opinions. They're going to ask you about your education, about your employment history, all the stuff that kind of will make you credible to a jury. The defense is going to ask you about that in a discovery deposition, and in a trial deposition, the plaintiff's going to ask you about that. And the difference between those things is a discovery deposition is part of the discovery phase of the case, which is the investigatory fact finding part of the case. And since you're essentially going to be a witness for the plaintiff, because you treated the plaintiff, the defense would likely be the ones to take your discovery deposition. And so what they're going to do during that discovery deposition is ask you questions about your medical records. And that's why it's important not to have the sideways mouth open guy, because you're going to need, because this is going to happen 2 or 3 years after you treated this person. You need to be able to quickly reference what you did to this person and why you did it, because that's what they're going to want to know. And so they're going to get really into the weeds about the details. They're going to go through those OATS assessments. See, I got the right acronym this time. They're going to go through all those 1 to 10 pain scales, and they may have some pointed questions for you that you don't necessarily like. But
Give us an example of that, Will. I'd
Oh,
love for our listeners to hear this.
an example of is it? Let's see. I'm trying to think of an example.
You'll get called by your first name. You won't
Okay.
be called
Gotcha.
doctor.
Yeah, they'll call you by your first name. They'll call you Chiropractor Jones instead of Dr. Jones. They'll just completely disrespect your education. They'll go on and on about how you didn't go to med school and this, that, and the other. They may whip out some arcane chiropractic textbook on you and be like, "Do you
That
remember
happened to me.
that?" Yeah, that did happen to her. I remember she came home and told me about that, and I was like, "That's about right." So these are things that they'll try to do to sort of throw you off. The important thing, and I'm just being honest, y'all, some chiropractors can be bad about this. The important thing is not to get defensive, not to get upset, but just stay cool, stay calm, and stay collected. And the other thing that they'll try to get you to do, and this is something that y'all need to be on guard, is they'll try, because look, we all believe in the benefits of chiropractic and what it can do for you. They're going to try to make you look crazy, honestly, because you may say something that they'll try to say, see, this chiropractor Jones thinks that this cures so and so. Like they're trying to get you to say stuff like that. So be very measured in what you say and be very careful, and you'll be just fine.
Yes, and if the defense attorney's goal is to make the chiropractor seem crazy, if you react to a lot of this, you will seem crazy. So I think it's good to sort of know some of this information before you go into a deposition. And the ultimate goal is to keep your cool.
Right.
So, can chiropractors, say we have a subpoena for a deposition or we are called to trial, this is going to take time out of our practice that we could bring in collections from our patients. Can we charge, first of all, can we say no? And number two, if we do go, can we charge for our time?
You cannot refuse a subpoena. That is a court order, essentially.
What if we have something that's already scheduled? Say we have a vacation we scheduled 6 months ago. In my case, one time I had an oral surgery scheduled, and it took me months to get that date. What do we do?
So here's what you do. Because I'm talking to, when I said that about it being a court order, because that's what it is essentially, is you're being commanded by an officer of the court, which an attorney is, to appear at a certain place at a certain time, and they can do that. But as a practical matter, that attorney would probably like you to, you know, they want you to be a cooperative witness, basically, that's going to, you're not going to hate them. Basically, they don't want you to hate them, come to there and just hate their guts. They're going to generally be pretty reasonable about working with you. I would bring that to the attorney's attention. Like, hey, I'm happy to testify, obviously, but I've got an oral surgery appointment scheduled that day. And 99 out of 100 times, and again, I practice law in South Carolina. There's some very cutthroat places in other parts of the United States where this might not be the case. You know, looking at you, Chicago or New York. But most places, if you do that, they'll be fine with rescheduling it because, well, A, they're not jerks, but B, they're not going to want you to be just irate with them the whole time, and then you're going to sit there and go, you know, you're less inclined to be cooperative at that point.
Well, how about can we charge for our time?
You sure can. Medical doctors do. Some of those guys and girls charge some ridiculous rates for their time. Let me tell you. But as long as you can come up with a time or a rate that's reasonable based on your collections and based on what you would reasonably expect to make in a day, or obviously you break it down by hour. If you can come up with your hourly rate that way, I think that's a perfectly reasonable thing to do. And as the witness, you can charge for your time. You know, getting that invoice paid, is different. But if you bill an hourly rate, that lawyer is going to pay it more than likely.
Who pays that? The attorney or the car insurance, the liability carrier?
So the way that works is, if it's the defense lawyer taking the deposition, like he notices the deposition, then his client is going to have to pay for it. And really, on his side, that means the insurance company. For the plaintiff's lawyer will pay for that out of his business, essentially, but he's fronting that cost for his client, aka your patient.
So do we bill the attorney's office or do we send our bill to the car insurance company?
You send it to the attorney's office because they're the ones who notice the deposition.
All right. So we are to the last part of this podcast, and we are talking about payment. So this is something that we all want to know more information about. So, Will, how do chiropractors get paid? Do we get paid from you? Do we get paid directly from the car insurance company? How do we get paid?
You get paid by the attorney. The attorney, when they settle the case, they get the settlement check, put it into their trust account, and any liens that need to be paid, they issue checks from their trust account to those parties after those disbursements have been approved by the client.
All right. So tell us, why does payment take so long? So say the case is settled. Why does that take so long?
Well, because you may not be the only lien holder. That's one of the biggest issues is, there may be a health insurance lien that's holding things up. There may be a hospital lien that's holding things up. The insurance company may have taken forever to send the settlement check. There's a lot of factors that go into that.
So when is it appropriate for us to check on the status of a personal injury case? Say it's been, what's appropriate? 2 or 3 months after the patient has had their last appointment, or do we need to wait until it's been a couple years? Like, when is that appropriate?
Well, I think it's appropriate to check in, I'd say, at the very earliest 60 days after they finish treatment. And that's kind of early. I mean, the answer is probably going to be, we're still waiting for a response, or we haven't set the demand yet. But I'd say anywhere from 60 to 90 days is an initial check-in. Obviously, keep your state statute of limitations in mind. South Carolina's is 3 years from the accident. That varies widely from state to state. So, for example, like if your client got hurt in a car accident that was 4 years ago and you don't know anything about a lawsuit being filed, like, it's not good for you. That's really not good for that lawyer. but if they haven't done that. But that's something to keep in mind as well. So you need to check in, I'd say 60 to 90 days initially. Then I'd say every, couple months or so after that, because it could be a while. And then once they tell you it's in litigation, well, it could be a couple years.
Yeah, tell me what that means when a law firm says that a case is, we've had this quote, in negotiations and quote, in litigation. What does that mean?
So in litigation means a lawsuit has been filed and it's in the litigation process, which, I'd say on average, it takes about a year from filing a lawsuit to get to mediation, which is the settlement conference where you try to get the case worked out. And then, if you don't get it worked out there, it could be another year before you try the case. And then in negotiations, that's a little more squirrely. Like that, if you're really in negotiations, that means you've gotten an offer from the insurance company and you're going back and forth with them. But if a law firm tells you like multiple times in 2 or 3 months that they're in negotiations, they are probably blowing you off and they don't want
Yes.
to talk to you. Yeah. So that your suspicion should be heightened a little bit at that point. Not that there's anything nefarious going on, like somebody's stolen your money or something like that, but like these guys are dragging here and like they're not doing what they need to do.
Well, what if it's been a couple years? Because this has happened to myself and I'm sure listeners. What happens if it's been several years? You're getting the runaround from an attorney. Is there a way as a chiropractor that you can find out if a case is settled?
So at that point, you should be very concerned that something nefarious is going on. You should be pretty worried about that at that point. And depending on where you live, like in South Carolina, you could look up on the public index whether a lawsuit had been filed. And then if it has, you can usually see what the status of that lawsuit is. If it's been dismissed, which generally means it's been settled, whether it's been tried, there'll be either a verdict or judgment there. And if neither of those things show up, perhaps the case is in litigation and it genuinely is still going on. But if you can tell that the case is finished, whether by dismissal or by verdict, and you hadn't got paid, that's a problem.
Can we call the liability carrier?
Yes. Whether they are cooperative or not, I don't know, but you could certainly reach out to them and ask them if the case is settled or if payment has been issued. Yes.
So what do we do if we find out that the case is settled and either the attorney won't answer our phone calls or they're just giving us the runaround and we know that case is finished and it's been months?
Okay. Well, if the lawyer won't call you back, you have an ironclad, valid assignment signed by your client that you can prove the lawyer has in their possession, and that and that you can show that this case has been settled and dispersed, and that combination is pretty rare. That you're able outside the lawyer's office to show all those things. You need to exhaust as many avenues as you can before you do this. You need to call the lawyer's office, email him, mail him a letter, show up to his office
A
if you have
paper
to.
trail.
Yeah, you need to create a paper trail, but you also need to give this person every opportunity that you can to cooperate and tell you what's going on. Because A, if you're wrong about this person will never work with you again. But B, to create a paper trail.
And C, make sure that you actually sent them a doctor's lien.
Well, right, because you can't send them a lien or assignment after the fact.
Or you think you sent it to them and then the patient signed, and because I've done this before where the patient signed a lien and we never sent it to the lawyer, which was our fault.
Yeah, you need to make sure that the lawyer actually receives the document before you do what I'm about to say. But if you can show all of those things and the lawyer is still blowing you off at this point, I think you're well within your rights to bring that up with the Office of Disciplinary Counsel, because lawyers have an ethical duty to deal with liens and assignments that they know about. And if you can show that somebody is like willfully trying to dodge you and not talk to you and will not respond to you, and you know that they've dispersed the case and that money's been paid and you didn't get paid, at that point, I think you're within your rights after you've exhausted every possible avenue to take it up with the administrative body that disciplines lawyers. And then they'll launch their own investigation. And if it is true that they avoided your lien on purpose, and they'll probably receive some sort of discipline.
Well, I appreciate that information because while it is rare, it has happened, and it that may have happened to one of our listeners, and it's good to know that there is something that we can do as chiropractors. So, lastly, in regard to payment, will you explain to me why chiropractors are asked to take reductions?
So sometimes that's because there's simply not enough money to go around, because of things like uh, limited amounts of coverage, and there being lots of other lien holders. Sometimes there's simply just not enough money to go around, and the lawyers will ask for there to be reductions, and oftentimes, if the lawyers are asking for reductions, they're probably taking a cut to their fee as well. Um,
Is
sometimes
this
that
normal? Is it normal to be asked to take a reduction?
Yes, very normal. And it's not just chiropractors. Y'all are not getting picked on. Like hospitals get asked to take reductions. Health insurance lien holders get asked to take reductions. I mean, it is a part of this process. Yes.
In your opinion, what is a normal and standard reduction that a chiropractor should take?
Well, I mean, part of that's governed by how much coverage there is, how much the case settled for. Because, like, for example, if there's $30,000 in medical bills and your bill's $5,000 of that, there's only 25,000 in coverage, you're going to have to take a pretty big cut. I mean, you're going to have to.
Why? Can you sort of explain the breakdown after when you
Sure.
go to settle?
Well, so in South Carolina, generally speaking, the equitable distribution of funds, if a court has to step in what's called an interpleader, basically where all the money is given to the court and the judge has to decide who gets how much. Customarily in South Carolina, a third will go to the client, a third will go to the lawyer, and then a third will go to the medical providers. So oftentimes in South Carolina, you're going to be arguing about of that $8,300 essentially on a $25,000 case. Um, that's not every case though. Sometimes there's plenty of coverage to go around, and if there's plenty of coverage to go around, and the lawyer just didn't get very much money on the case, unless there's some reason for it. Like, for example, say there's disputed liability, like it's not clear whose fault it is. That's going to drive down the value of the case. Say that causation is not clear. In other words, there's not a lot of property damage. That's going to drive down the value of the case, and the lawyer is going to probably have to cut his fee. So those are cases where reduction requests come into play.
Well, what happens if I decide not to reduce my bill?
You could do that. However, especially in a case like I just described with, more bills than coverage, that lawyer is probably going to have to file an interpleader with the court where the money is paid into the corporate court's trust account and the judge decides who gets what, and you're going to end up taking way less. And, at that point, that lawyer's probably not going to do business with you again. Which, if that's not something you're worried about, that's okay. But if it is something you're worried about, that's something to consider.
And this is why we want to be in a position as chiropractors where we don't rely on personal injury income so that if, things do go sour with an attorney, it's, that's not how you're paying your staff and feeding your family. So in our case here, one of the things we typically will reduce our bills by 20%. That seems to be pretty normal. But my suggestion for practice owners and for chiropractors is a lot of times attorneys, they will send over a reduction request or they'll give you a call and they will just ask you to reduce your bill. So instead of just giving out a reduction, the tactic that I typically use is I ask the attorney, how much would you like for me to reduce? How much of reduction do you need? Because if you automatically tell them you'll reduce by 20%, they may not have asked you for that. They may have asked you for a 5% reduction or a 10% reduction. So that's a way, don't cheat yourself out of money. You did render this treatment on this patient. So typically in our clinic, we will reduce by 20%, but sometimes you're not even asked to reduce that much. Sometimes it's more, and sometimes it's not. So lastly, I have one more question for you, Will. So, why do some law firms ask for reductions months or sometimes a year before a case is settled?
The only real, like, legitimate justification I can think of for that is if you have a case that you think is going to settle, right? You think is getting close, and so your client wants to know. And this is a question we get all the time: how much money am I going to get? Well, to answer that question, you got to know how much money you got to pay everybody else. And so you might go around and start asking for reductions, and then one of two things happens: either the insurance company doesn't pay what was needed to pay to get the case settled, or your client changes their minds, like, you know what, I don't want it. I could see that happening, but generally speaking, there's not really any reason why somebody would be asking for a reduction if the case hasn't already settled, or isn't like imminently about to settle.
All right. Well, that wraps it up. And we learned a lot of information today. And thank you so much, Will, for being a guest speaker on our podcast. If you guys have any questions or things that you would like answered by Will, just send me a direct message on my social media channels, Dr. Mary Frances Duncan, or you can submit a question on our website.
Thank you so much, Dr. Duncan and Will, for that amazing conversation. I feel like I even took something away from even those little tidbits. So I'm sure that practice owners that are listening are taking things away as well. So again, thank you both. If you took anything away from this, please check out Dr. Duncan's website, drmaryfrancesduncan.com, where you can also, like she said, ask questions or look into online courses or coaching that she offers. I'm sure that she would go into so much more detail on all of these topics, one-on-one coaching or looking through the courses. Additionally, if you took anything away from this as well, please give us a review. These 5-star reviews, they help us. We take away things, and we also know that you're enjoying what you're listening to. Additionally, you can check us out on socials, Dr. Mary Frances Duncan, and give us a follow so you can stay in the loop as to what we're posting and when we're posting. That's really helpful for us as well to know who's staying in and who's staying tuned in to what's going on. So again, thank you so much for listening today. Dr. Duncan, do you have anything else before we leave?
I think we covered a lot today. Thank you for listening. I know this was helpful for me, and I hope it was informative and helpful for our listeners.
Absolutely. So thanks again, and we will see you in the next podcast of I'm Simply Saying.
Ding-a-ling-a-ling, ding-a-ling-a-ling.